And when that F-bomb came out, he was facing that back row, was he not?
Yes, sir.
You were literally hunting in the dark. Were you not?
At that point, no.
Judge, I'm going to object. First of all, I object to the form of the question, hunting in the dark. What is that referring to? How is that relevant? In what context? I mean, I can go on and on and on. You're hunting in the dark?
Sustained rephrase.
You were doing the best you could trying to see what little you could see.
Correct.
Now,
Excuse me.
now the first thing that you see, even before the F-bomb, the first thing that you see Mr. Olson when he stands up and he is leaning over the back of his seat. Mr. Olson, correct? Leaning over the back of his seat.
No, sir.
2/5/14, the bond hearing that took place very early on in this case. Page 344, lines 23 through 25, and page 345, lines 1. Remember the following questions and
Hang
answers.
on a minute.
Judge, he's going page 344. I mean, he's got to give me a chance to get there.
Okay, I'll let him, let me
Page
get there. My apologies.
344.
Lines 23 through 25, page 345, lines 1.
Judge, I'm going to object because this is taken out of context. If you go further on in the bond hearing, I have Sergeant Hamilton step down and demonstrate for them, the sitting judge, Judge Syracuse, and he demonstrated exactly what he demonstrated here today.
Judge, I'm going to go through that whole line of questioning.
He never says that he was leaning over, and he gives a demonstration, Judge. Mr. Escobar takes bits and pieces of what he wants, and then he leaves the other stuff out.
No. Judge, that's not correct. The question and the answer is right there. It ends on page 1 of 345, and then we actually start talking about the issue of propping. That's going to come next.
And Judge, I would assume if you asked Mr. Escobar further on in that bond hearing, Sergeant Hamilton stepped down and literally demonstrated for the court how Mr. Olson was back on January 13th of 2014, and he never says that he was leaning over the chair.
Judge, he says it under oath in this particular document. You want to read it? I can show it to you.
Let me see it.
344, starting on line 23. 345. That's the initial answer, and then we go into what propping is.
No.
I'm sorry, you didn't do that. I'm sorry.
And it appears the question, I guess by you, said he's leaning significantly over his seat, and he doesn't say yes, he said he's propped.
Judge, here is my question, okay? And so the first thing that you hear and see is Mr. Olson when he stands up and he is leaning over the back of his seat, Mr. Olson does.
Right.
And he says,
showed that
and he
already.
says,
Right.
correct, yes, sir.
Right, he already showed exactly what Mr. Garcia said.
He just said that he wasn't leaning over his seat.
Judge, I would invite the court's attention to page 351, line 7. He was leaning over into Mr. Reeves' face, correct? Answer, no, sir. And then there's a demonstration. He was in a propped position. Like I said, you cannot take these transcripts out of context. You can't take the bits and pieces that help you and leave the other stuff out.
It's not a significant inconsistency. I'm going to sustain the objection.
Now, propped. That's what you said on direct, right?
Yes, sir.
Well, if you didn't see from the waist down, what was he propping on?
I don't know.
Well, but if you say he's propped, what is he propped on if you can't see from the waist down?
He could have had his hand out at a lower spot. He could have had just his knee. I mean,
Well,
what
but
I found
if-
out
if-
later on, he's a tall guy. I mean,
But if you don't see that,
Judge, I'm going to
Sergeant.
object, it's asked and answered. He just gave an explanation. Mr. Escobar doesn't like it, so he wants to keep
No,
asking.
Judge, I like his answer because he can't tell us what he's propped on. What's he propped on?
I don't know. I'm just telling you he's propped.
Sustained, move on.
Certainly at that point in time, you could see that Mr. Olson was a tall gentleman.
At what point in time, Judge? I'm going to
At
object.
that point in time, when he's propped, when he's propped.
When he's propped?
Yep.
No, I don't see that he's a tall gentleman at that time.
Page 345. Lines 8, right? 2 sentences after he's propped. 345, lines 8, all the way through 25.
Judge, I'm going to object, though. You've got to put it in context.
Who says he was tall when he was propped? Is it the question, the way the question
No,
is?
Judge, the
Judge, I-
question is, as you can see Mr. Olson there, he's a tall gentleman, correct? Yes, sir. At what point in time? At what point in time? That's what you have to reference.
He's already said earlier, yes, at some point he saw he was a tall gentleman.
No, Judge, this is at this point. If I can just, I'll give you the sentences.
What's the relevance?
The relevant is that he's making a assumption at this point in time that he's propped. He can't even see what he's propped on. But what he can tell is, he can tell that it's a tall gentleman. And what that tells you is that he's not propped at all.
Let me see then. Let me see where he says he could tell he was tall when he was propped.
It starts here, right here from 2.
It says, you could see Mr. Olson there, he's a tall gentleman. It doesn't say he's a tall gentleman when he's propped.
Judge, the first 3 sentences are about being propped. He says he was propped, and I go into, you could see that he was a tall gentleman.
Finish the questioning. You may expound. It is not impeachment. Ask him the question. And he's already said he doesn't know what he was propped on, so move on from there.
Was he a tall gentleman?
I found that out later on. Yes, sir, he was a tall gentleman.
So later on is when you found that out. How did you find that out later on, since this gentleman was on the floor when you got to Mr. Reeves?
When, after he was shot, he stood up from that prop position, and then his body elevated from there, and that let me know that he was a tall individual due to the size of the chairs.
That's when you first determined that he was tall.
Yes, sir.
Now, you're still seeing initially, when he's, quote, propped, the silhouette that we talked about before.
Yes, sir.
Hold on a minute, Mr. Escobar. Is there a problem?
There you go. Go ahead.
When you heard the F-bombs, did you expect to hear that in a theater?
No, sir.
Just the loudness alarmed you.
The tone and the word itself, yes, sir.
And again, you only were hearing Mr. Olson, correct?
That's correct, yes, sir.
You never saw at that moment Mr. Olson with a phone in his hand, did you?
No, sir.
You didn't even see Mr. Olson's hand reaching into Mr. Reeves's person, correct?
No, sir.
Why couldn't you see that?
I don't know.
So you
Maybe it
didn't see
didn't
it
happen.
once, you didn't see it twice?
I didn't see it.
Everything happened pretty quickly.
Yes, sir.
Did you see the muzzle flash?
Yes, sir.
But you didn't see the gun?
No, sir.
And why was that?
And it's a black gun.
Because of the darkness?
Darkness, small gun.
Now, you got up from your seat, correct?
Yes, sir.
And even before getting up from your seat, you never saw Mrs. Olson, did you?
No, sir.
And you still hadn't seen Mr. Reeves?
No, sir.
Because it was dark?
He was sitting down.
No, because it was dark.
No, because he was sitting down.
Just because it was sitting down.
I couldn't see him. I couldn't see the rest of the people in that row because they were sitting down.
What about
So you
Mrs.
get-
Olson?
Mrs. Olson? No.
Because it was dark?
No.
Just object, that's an answer. He's already answered the question 3 times.
Hold on.
Now, you go over to Mr. Reeves, correct?
Yes, sir.
And when you get there, Mr. Reeves is seated,
That's correct.
correct?
Yes, sir.
And the firearm is on his left knee.
That's correct.
His hands are away from the firearm.
His hands were either retreating or going forward, and I believe I said that I wasn't paying attention to that, but they were not up here.
No, I know, but they certainly weren't on the gun.
No.
And I believe you yourself indicated that you very quickly, once you were able to get the gun, you wanted to put that gun out of sight.
That's correct.
Because you didn't want someone seeing you there in plain clothes, correct?
That's right.
With a gun in your hand,
Yes,
in a
sir.
dark theater.
That's correct.
That's not a good situation.
No, sir.
They may misconstrue you as being someone that's being aggressive.
That's correct.
And that's even before police come in. Talking about general population there.
Yes, sir.
You've certainly been trained on those issues, have you not?
On,
Making sure that, hey, if you're in a place and you've got a gun, put that gun away so that nobody realizes that you're, or mistakes that you're a threat.
I've had no training on hiding guns to keep people from knowing what I am.
Just common sense?
It's common sense.
Okay. Now, you never told Proctor, did you, that Mr. Reeves wanted to leave?
I don't recall whether I did or I didn't.
Well, you remember Mr. Reeves saying he wanted to get up.
That's correct.
As Mr. Reeves was seated there, did you see him put his hands to his head?
Yes, sir.
And would you describe to the court what you saw?
He, when I approached him, and me and him understood that, I was a law enforcement officer. I'm there to, make sure we keep everything under control from there. He reached back and pushed his glasses up over his brow and asked me if I he was hit, did I see anything? And he said he had something in his eye, and I believe I said, well, because he had his finger here, and I said, well, that's your finger in your eye.
Had his right finger in his eye?
He had a finger in his eye. I don't know which finger it was.
Well, what eye?
And would have been his right eye,
His right eye.
or left eye, excuse me.
How long did it take you to get from your position? You were seated when the gun went off.
Yes,
And so since we have a camera, we have the benefit of having some timestamps, right?
that's right.
Now, you didn't know that there was a camera in that theater that day at all.
No, sir.
Even when you gave your statement, you had no idea.
No clue.
And so you had to get up from a seated position, correct?
Yes, sir.
And you had to get up, and then you had to make your way to Mr. Reeves. So do you know how long it took you to finally get to Mr. Reeves?
No, sir, I don't.
And you don't know what Mr. Reeves was doing from the time that you decided to get up to the time that you reached him.
No, sir.
You certainly didn't think that Mr. Reeves wanted to flee.
Objections, cause for speculation. He has no idea what was in his mind.
I think he just answered no, with his head at least.
And I'm objecting, it calls for speculation, Judge, whether he answered or not.
One thing's for sure, the minute that you got there, and when I'm saying you got there, we're talking about you got there to Mr. Reeves. One thing's for sure, is as you looked down, in between his legs, you saw that phone.
I don't know if it's that phone, it was a cell phone.
It was a cell phone, dark in color.
I don't know. It's dark in that area. Was in between the seat and my feet. So
So-
I can't tell you what that's the.
So
actual
because
phone.
of the darkness that we had in that theater, and you were standing right next to Mr. Reeves, and you were looking down, and you couldn't tell what color it was.
No, sir. I mean, since you pulled that out of an evidence bag, I would assume. that
Well, we
that's-
we certainly can't assume in these cases. You just didn't know what the color was.
Right, exactly.
Now, when you introduced yourself to Mr. Reeves, he likewise indicated to you, hey, I know I'm a former law enforcement officer, right?
Yes, sir.
And you certainly did not have to handcuff him there, correct?
No, sir.
He sat there quietly.
Yes, sir.
And he asked you, told you he'd been hit, correct?
Yes, sir.
And so certainly, if you couldn't see a cell phone a mere few feet from your person because of the lighting, right?
That's correct.
Could you tell the court what lighting, if anything, you used when you were trying to examine whether Mr. Reeves was injured in any way?
Well, there was a pretty significant difference between the floor and me standing within, this proximity of Mr. Reeves. I mean,
So from here,
Judge, I'm gonna object.
I'm asking him a
Mr.
question.
Escobar is not even letting him answer the question. He interrupts him. When he goes to answer, then he wants to ask him another question. I'd ask him to at least extend the courtesy to the witness to let him finish his answer.
Let him finish.
a little bit of difference in the lighting. quite a bit of difference from down there in the dark, underneath the seat, in the seating area. His legs are shadowing, my body's shadowing that. So where the light is up here is significantly better than what it is in the floor.
So what did you
So-
do, what did you do in checking, Mr. Reeves? What did you use a flashlight?
No, sir.
Okay, well, tell me physically what you did in order to check whether, did you get down real close to him and look at his head?
Judge, I'm going to object to Mr. Escobar being a foot away from the witness. I don't know if he's trying to intimidate him. I'd ask him to go back to the podium.
I'm talking very, very low. Did you get real close to him?
No, sir, I didn't, I wasn't looking for, whether he had, a needle side. I'm looking for any significant injuries, bruises, gashes. He's got a red mark inside of his eye that, you know what I mean?
Yeah,
That's-
you're looking for something significant.
Right. And I'm
Okay.
not seeing any of that.
Now, again, you were concerned, one of your concerns right there was, hey, listen, at some point in time, officers are going to be coming through that door, and they're going to be coming, maybe guns blazing, and that can be a pretty dangerous situation.
There was a number of things on my mind, yes, sir, during that period of time that would have affected me and him.
But that would have been one.
That's one.
And you remember Mr. Reeves' son coming up and chatting with you as well.
Yes, sir.
Now, while you were there, you really didn't want to talk to Mr. Reeves, did you?
Which one?
Not the son, I'm talking about...
Mr. Reeves?
Yes.
Not really, no, sir.
Now, you indicated that there was a conversation that you heard between Mr. Reeves and his wife.
That's correct.
And you said here in direct examination that Mr. Reeves said something to the effect of, shut your fucking mouth? Or was it shut your fucking mouth? Was it something to the effect of shut your fucking mouth? Or was it shut your fucking mouth?
It was shut your fucking mouth.
It was shut your fucking mouth. So it wasn't, there was no cause to shoot the man. Don't say another word. That wasn't it.
No, you asked me what he said. That's not what he said. That's what his wife said.
Okay, well, I'm worried right now about the shut your fucking mouth. Who said that?
Mr. Reeves did.
Well, did Mr. Reeves say shut your fucking mouth, or did he say don't say another word?
He said,
Object.
shut your...
Asked and answered that already.
Which, are those exclusive of one another, or?
They're different.
No, Judge, it's the whole same phrase. He testifies, he said, shut your fucking mouth and don't say another word.
So it's both. Shut your fucking mouth and don't say another word.
No, sir. He said, shut your fucking mouth and don't say another word. And he had his finger, his index finger pointed at her.
Now, you've been a police officer for how long?
Close to 20 years.
Okay. And you certainly realize the importance when a police officer is going to interview you with a recorded statement.
That's correct.
The whole purpose of the recording is to memorialize your recollection as close as possible to the event.
That's correct.
And you certainly, being a police officer, recognize that certainly someone saying, shut your fucking mouth is pretty important.
That's correct.
In fact, it's a crime. Tampering with a witness. right?
That's correct.
And so if you're going to be interviewed by a detective, you want to be 100% truthful, right?
That's correct.
Especially if that is going to be recorded. And if the detective is trying to find everything that he can about the case, is asking you, tell me everything you know.
Right.
And you remember Detective Proctor telling you just that.
I don't recall him telling me everything you know.
Well, did he tell you at the end of your statement, anything else you can tell me?
I could read it off of that now and tell you, okay, that's probably what he said, but I'm just telling you, I don't recall him making that comment at that time.
Or would you like
tell
to
me
hear,
everything.
would you like to hear it on tape?
No, I don't need to hear it. I'm sure I said it or he said it. I mean, it's on there. I mean, I'm not going to deny it or say I'm just telling.
So when he told you that, was this just insignificant enough that you just, I'm just not going to tell him about it?
No, sir. It's not it at all.
Well, there's another document that's very important. And this is even before you get to Detective Proctor, correct? It's called a voluntary statement form. I'm going to show you what's been marked as Defendant's Exhibit number 215. May I approach you?
Yeah.
I'm going to ask you if you recognize that document.
Yes, sir. I do.
Now, when you wrote that document, how long had you been in law enforcement?
It's about 17 years.
You're a corporal at that time,
That's correct.
and you realize that the purpose of that document is that you're trying to give totally truthful information, right?
That's correct.
And you're trying to give important information
That's correct.
concerning what you know about the incident.
That's correct.
And certainly what you know about the person that's being accused of shooting, right?
That's correct.
And now you've just admitted also that, hey, the statement, shut your fucking mouth, is pretty important.
That's correct.
In fact, you've admitted today it was a crime.
That's correct.
But you never put it in that statement, did you?
No, sir. I can explain that if you want.
Please.
Okay. We, meaning me and my wife, had just got through with a pretty significant incident. We were given pens and a piece of paper and asked to fill out a statement on the carpet. So when we're doing that, I'm thinking I'm going to give them everything that I know right now and sign it so that we have some account of this, and that was it. And what I said earlier is preliminary. This gets the detective or whomever's going to work the case the evidence enough to establish probable cause to arrest whomever the shooter was.
Okay, so this was done on carpet? Pretty neat writing, correct? If I was to put this down here on carpet,
Judge, I'm going to object to the relevancy of Mr. Escobar putting it down on carpet. He's already testified, he wrote it on the carpet.
so you and your wife were on the floor on the carpet writing this down.
We had been on the carpet, we had been on a railing, wherever we could find. There was numbers of people in there trying to fill out statement forms.
So are you blaming it on the carpet that you just didn't put it down?
No, I'm not blaming-
Judge, argumentative.
Sustain, move on.
You just have no
Or
reason for,
rephrase.
you have no reason for not putting it down.
I don't think that's my,
He's already answered this.
I heard him answer that. He said,
I
let
object-
me explain. So I think that was the answer. Let's move on, please. Sustain.
Now, you just told me that you and your wife were very emotional about this case, correct?
Yes, sir.
You were emotional there at the scene?
No, I don't believe so.
So you were?
Not at the time.
So did you get emotional after you left the scene?
I had my mixed feelings, and I was trying to hold it together for my wife because she was extremely upset. She doesn't, what she does for a living doesn't, she's not, around that particular type stuff. So yeah, it's taken a toll on her.
Okay, but I'm saying at the scene, you all weren't emotional, is what you're telling me.
She was, I
She
wasn't.
You weren't. Now, do you remember there at the scene when you were there right beside Mr. Reeves, you telling your wife to back off?
Yes, sir.
And you believed at that point in time you were rude?
From what I was hearing and what I was seeing, if I had to be rude with her to let her know that she didn't need to be on my back to protect my back, yes, sir. There's a whole different context there.
Well, you agree that it was a stressful situation for everyone?
Absolutely.
And you're the kind of person that talks with your hands as well?
Yes, sir.
And you agree that at that point in time, still the law enforcement officers had not come through the front door?
That's correct.
And so you were worried about that?
Judge Object asked and answered. That was asked 10 questions ago.
All overruled. I'm sure you're getting to a point that you haven't already asked.
Officers come in?
Yes, sir.
Mr. Reeves very cooperative?
Yes, sir.
And before they took Mr. Reeves away, were you a little confused about what had just happened?
About them handcuffing him and taking him
No,
away?
the whole process, you coming up to Mr. Reeves, seeing the gun on his knee, his verbal interaction with you, and his verbal interaction with his wife.
I don't think I was confused. I don't think you could use confused.
Well, were you sure about what was being exchanged between all the parties as far as verbal? Or were you just kind of saying, well, I kind of had, an idea of what was being exchanged, but I can't tell you verbatim what was being exchanged?
I didn't have any thought process like that.
Were you 100% sure of what Mr. Reeves told his wife?
Yes, sir.
Page 116. Lines 4 through 18. Judge, would you like to see it?
Let the prosecutor have a chance to read it first. Is there an objection?
Yes, Judge, it's consistent with what he's already previously testified to.
Judge, I want you to read it.
Let me see it.
Page 116, lines 4 through 18.
I'll overrule this.
Now, Detective, we're talking about, obviously, that conversation that you allegedly overheard of Mr. Reeves telling his wife, shut the fuck up. Remember the deposition that I took of you on
March 20th, 2015.
March 20th, 2015?
Yes, sir.
Remember being placed under oath?
Yes, sir.
Remember me asking you the following questions and you making the following answers. Question: do you remember 100% of what he said to her? Answer: again, when we're playing with the thes and the I's and the those and ins and outs, it was within the realm of basically hush your mouth, don't say another word. Or shut up, don't say another word. It's basically telling her, you don't need to open your mouth no more. I don't need you in this any longer. So whatever context that may have been, or whatever, how word, by word, I can't say, but he scolded her. If we had a recording on it, yeah, I could tell you, yeah, that's what she said, but it was a stern scold. You said that under oath, right?
That's correct.
And this was closer in time to the event than today.
That's correct.
And you were telling me the truth when we took this deposition, correct?
That's correct.
Now, you were armed that day yourself, correct?
I had a weapon with me, not on me.
Meaning that when you went over to Mr. Reeves, you didn't have a weapon on you.
No, sir.
That was in your wife's purse back at the seat?
Yes, sir.
And does she have a concealed weapons permit?
No, sir.
And so you went in that day with a firearm, despite the fact that
Objection is to relevancy, Judge.
they brought it out during Mrs. Reeves about the little signs that say, don't bring your weapons in. You brought your weapon in, despite the fact that there were these little signs that supposedly say, can't bring a weapon in to the cop theater.
That's right.
Now, one of the things that happened immediately, when the officers came to arrest Mr. Reeves, is that you told the officers, hey, I want to let you know, there's a cell phone right here between his legs. Correct?
That's correct.
Because you realized that that was a potential piece of evidence.
Yes, sir.
And you wanted them to make sure that they could secure that
Yes, sir.
right away.
Yes, sir.
Now, Detective, you seem a little emotional here today. You still emotional about this case?
I didn't think I was emotional today.
But you actually cried at the demo I took of you.
That's correct.
Judge, how is this relevant as far as his emotions go?
Because emotions affect testimony, Your Honor.
Really, Judge?
Oh, yes,
Really
really.
want to get into this?
Really, it does.
All right.
Then Judge, if he wants to get into that, then let's have Mr. Hamilton explain why he was so emotional.
I'm gonna,
No, Judge, I want him, no, he's opening
I'm
it up.
gonna overrule the objection. He can get into emotion to some extent, but I do want the record to reflect, Mr. Escobar, you just said you appear to be very emotional here today.
And he said no.
And he did say no, and I want the record to reflect that I don't see any visible signs of a motion.
Okay,
Proceed. And you can bring out whatever the door has been open to.
Okay, I accept you, Judge, because it,
You know.
did the officers pick up that phone?
I don't know.
Now, after Mr. Reeves was taken away, the officers moved you to another location, correct?
Yes, sir, eventually.
In fact, moved all the witnesses.
I don't know where they went.
Well, didn't the officers have all the witnesses in the theater sit in a certain area?
I don't know, I didn't orchestrate that, so I don't know where they sat.
Page 127, starting on line 18 through 25. We're going to direct your attention to the area that you were seated on the floor with your wife.
Okay, in the theater?
In the theater.
Okay.
Were you seated on the floor with your wife?
Yes, sir, at some point in time.
Okay. Had law enforcement come up to you and told you, Corporal Hamilton, you're not supposed to speak to anyone about what you had seen in the theater to anyone else?
I don't remember them saying that.
Did you see any of the officers there speak to any group of people and tell them you're not to speak to anyone about what you had seen in the theater?
I didn't hear that.
And so how long did it take you to write that statement?
I can't be exact how long it took.
But when you finished that, you and your wife were requested to go and have an interview.
Yes, sir, that's correct.
Page 138 is coming. Your wife went with you,
That's correct.
and she went in the room with you
Best I remember, yes, sir.
while you were being interviewed.
Best I can remember, yes, sir.
Well, let me ask you a question. Do you normally interview individuals, two individuals, at the same time in the presence of each other that have witnessed an event?
I don't.
Because you realize, do you not, that there's a great danger with the issue of witness contamination?
Well, I sleep with this witness.
Oh, so is that different? So you can't contaminate a witness you sleep with?
Judge, I'm going to object. He's being argumentative with this witness.
Judge, he just said he sleeps with her. It's a relevant question.
I mean, whenever we were talking, he was, I think, trying to accommodate us. But when you're asking me that, what they do with their policies and procedures, I don't know. If you're asking me, would I do that personally in a law enforcement capacity while I'm working? No, sir, I would not.
Okay. Because of contamination.
Could be.
Now, let's talk a little bit about that recorded interview, because you realized it was going to be recorded, right?
With the detective?
Yes,
Sir?
yes, sir.
Yes, sir.
Now, I believe you already testified that the vulgar statement that you had attributed to Mr. Mr. Reeves telling Mrs. Reeves, you believe that that was an important statement for you to share with Proctor.
That's correct.
And as you sit here, you really can't imagine any scenario as to why you wouldn't have told him that.
I mean, I asked the questions that he answered the questions that he was asking.
But listen to my question. It's a yes or no question. So as you sit here today, you can't imagine any scenario why you wouldn't have told him that.
No, sir.
But you didn't.
No, I didn't.
And you didn't put it in your voluntary statement form.
That's what it
That's
is.
an answer, Judge.
Sustain.
If I have a moment, Your Honor. Your Honor, we'll supply the proffered pages to the court as soon as we pull them and copy them.
Thank you. Read the rest.
Yes, Judge. May it please the court, counsel. Sergeant Hamilton, have you had an opportunity to view the video in this case?
Yes, sir.
And immediately after the shooting, there's a person who walks over to Mr. Reeves, right?
Yes,
In
sir.
that video? Can you tell the court who that person is?
Me?
It's you, right?
Yes, sir.
So immediately after the shooting, you walk over to Mr. Reeves and he has the gun on his left knee.
Yes, sir.
And you take it from him, right?
Yes, sir.
So clearly when Mr. Escobar in cross-examination asked you what time you got into the movie theater or a question to that effect, and you said 1:30. That was not right, correct?
That's correct. I have notes to say different. I was incorrect in that statement.
Okay, because clearly that's you on the video, right?
Yes, sir.
And the person that had this knee on his gun, or the gun on his knee, do you see him in the courtroom? Can you point him out and describe?
Yes, sir. He's here in a dark blue one-piece suit.
Okay, in the middle?
Yes, sir. In the middle.
Did I ask the record to reflect that Sergeant Hamilton has identified the defendant in this case? And the things at which you testified to here this afternoon, did you actually see those events?
Yes, sir.
Nothing obstructed your view, right?
No, sir.
Sergeant Hamilton, do you recall testifying at the bond hearing back on, between February 5th and February 6th of 2014?
Yes, sir, I do.
And did you testify in that hearing?
Yes, sir.
Judge, I would invite counsel's attention to page 334, line 1 of the bond hearing.
What are we doing?
334 of the bond hearing, Judge. This is a consistent statement. It's being offered as a consistent statement. He has attacked him. He's attacked him as far as what he said. And this goes to show that this is a consistent statement that he stated back on that date, that Mrs. Reeves indicated or stated to Mr. Reeves that was no cause to shoot anyone. And then he leaned back around and stuck his finger out, as to, scold her and said, "You shut your fucking mouth and don't say another word." Sergeant Hamilton, would you agree with me that February 5th and 6th of 2000...
Judge, that's lady.
You're right.
I'll rephrase.
Sustain.
February 5th and 6th of 2014, does that come before March 20th of 2015?
Yes, sir.
So the bond hearing would have been closer in time to this event, right?
That's correct.
And Sergeant Hamilton, just because you didn't put it in your written statement and you didn't put it in your tape statement, doesn't mean that it wasn't said and it didn't happen.
Objection, Your Honor, it's leading.
Sustained, rephrase.
In your deposition, you did not use the exact words.
Objection, leading.
Did you use the exact words in your deposition? I'm sorry?
No. In my,
Yeah, in your deposition.
no.
Why?
You know, I mean, I had, you know, two attorneys firing at me from one area and one from the next. I mean, it's kind of hard to keep up at that pace. You know, you're going to make a mistake somewhere in there. You're going to make that wrong, you know, wrong thing. And there's no sense in backing up out of that. You just got to keep moving forward. So, I mean, when you're two against one.
Let me ask you this, Sergeant. Was there a lady present in the room?
Yes.
Do you normally speak like that? Do you normally say those words?
No, sir.
Was it hard for you to come here today to say those words?
For the second time, yes, sir. Again, from the first time that all this was on the news, I kind of caught a scolding of reference to it.
You normally don't talk in that manner, do you?
No, sir, not in public.
And we saw that here today, right?
Yes, sir.
May I have a moment, Judge?
You may.
Have that for further reading.
Detective, you know that when we took your depo, it was recorded, correct?
Yes, sir.
There was a tape recorder there in addition to a stenographer,
That's correct.
so that we can take the oral questions as they're given to you as well as your answers.
That's correct.
Was there an attorney badgering you during that depo?
No, I didn't say badgering. I just said that there was two attorneys and one of me.
Were
So-
both attorneys asking you questions at the same
Period.
time or one at a time?
Periodically, and back and forth to it.
You're saying that myself and Mr. Michaels were asking you questions at the same time?
No, if you wanted to expound on what he said, you'd break in and vice versa.
And so clearly the recording of that would,
Judge, I'm going to object. First of all, the relevancy of these questions. Second of all, he's argumentative with the witness in the form of the question. I object to the form of the question.
the relevancy, he opened the door. He was the one that said that the
Open the
reason,
door to what?
opened the door to the fact that he's saying, well, it was just two lawyers and, you know, it was such a chaotic, you know, scene there. And we've got a recording of that it wasn't chaotic at all. In fact, we were very pleasant with him.
Sustained, move on.
No further questions, Your Honor.
May this witness be released? You're entitled to, it's your witness, you're entitled to have the last word. Do you need any more? May this witness be released?
Yes, Judge, it's just subject to recall if need be.
All right, you're still under subpoena, Sergeant. Not likely you'll be recalled, but it's a possibility. Please make yourself available. If you should get called back, hopefully you'll get plenty of advance notice. But you're free to go today. Thank you, sir.
Yes, ma'am. Thank you.
Break? All right, we need a break. How many more witnesses? One. Let's take 10 minutes.
All right.